Okay, why don't we get started? So I am so pleased to introduce today's program, which is focused on what happens when excessive force by law enforcement leads to litigation in either criminal system or in the civil system. Our panelists will be well known to many of you. I'll keep my introduction of them very brief so we can jump in. Professor Julie Shapiro mainly teaches civil procedure and family law courses, but before joining us at SU, she litigated police misconduct cases, ultimately co-founding a civil rights law firm before entering solo practice. Professor Leonard Feldman has just joined us this year as a professor from practice. That follows on the heels of a 30-year career as a litigator specializing in appellate practice. Of particular relevance to today's panel, Professor Feldman argued 2 cases involving police shootings in the US Supreme Court. Those were San Francisco v. Sheehan and Los Angeles v. Mendez. Professor Mike Russo is a distinguished practitioner in residence. Before joining us, he was a deputy public defender in Los Angeles, where he focused on homicide cases and death penalty litigation. The 3 panelists will speak for something in the neighborhood of 10 minutes each, and then there will be time for questions. For the question period, you can either just raise your hand and I'll call on you, or if you prefer, you can send me your question in the chat and then I'll read it out to the group. And with that, I want to hand it over to Professor Shapiro. Thanks so much.
Okay. I guess I just want to say a word to fill in one little piece about my background beyond what Charlotte said, and that's that I practiced in Philadelphia in the 1980s mostly, and the vast majority of my practice was 1983 cases in federal court, which is to say police misconduct cases in federal court, largely cases against the Philadelphia Police Department. And it is really, a lot of what I have to say today is really drawn on that experience, I think. And I know that that seems like it's a really long time ago, but I think it is regrettably still relevant experience. I'm not sure that much has actually changed. That's something to sort of think about. I've also taught the stuff more recently than that, so that there is some stuff that I actually am more up on. I want to start by saying, to some extent, this is a follow-up on the program several weeks ago that involved Mike and Professor Ahrens, and they talked about the criminal case or lack of criminal case in the Breonna Taylor case. And that makes me think in terms first of drawing a distinction between what I'm going to very loosely call big cases and all other cases. And by big cases, I mean the cases that result from catastrophic injuries, primarily shootings, primarily deaths. There have been a series of those recently, and I don't actually know that it's particularly that there have been more police shootings recently as much as there has been more attention paid to them and more litigation around them. But those cases, I think, the civil cases and in general, the whole constellation of legal issues you get around those cases are different from what I'm going to talk about as kind of smaller or more run-of-the-mill cases. In the really big cases, like George Floyd, you get obviously very high publicity. Those are the only cases, I think, and I mean, panelists can disagree with me, but I think those are the only cases where you're even potentially going to see criminal prosecution of a police officer. That's just not a possibility in most cases. Very high profile. And there's special cases. I mean, those cases have settled. Several of them have settled, I think, remarkably quickly for large sums of money. I'm not sure overall. Oh, and actually the Breonna Taylor case even settled for some institutional change, which is really remarkable, not a settlement you'd ever see in most cases. So I think those cases operate kind of in a different sphere. And while the law governing them is the same as all the rest of the law, I mean, the law is the law, right? I think those cases are different. And I want to focus my remarks less on those and more on what I think of as the sort of much more typical cases, much more common cases. I mean, for every police shooting, I bet there's like 1,000 interactions that are not shootings that could potentially lead to litigation of some sort. And I guess what I'm thinking about primarily is the way the police interact with members of minority communities generally. And, it could be that we're talking about what are relatively low levels of police violence, by which I mean no one goes to the hospital, right? And sometimes we're talking about false arrest. Sometimes you could just be talking about kind of stop and frisk, right? I mean, there's a whole array of ways in which the police make their presence felt in minority communities, many of which are oppressive, frankly, but fall way, way, way below the level of the kind of high-profile cases. And I think what those reflect in a lot of ways is a broad culture within police departments about, and within police departments about how police behave, how they treat certain kinds of people. And in some ways, I think that culture is what lies behind the shootings. I think obviously there's more there, and you can talk about the shootings in lots of different ways, but I think there's a kind of general culture about the ability of the police to stop anyone they want and to treat them pretty much how they want, that leads to, from time to time, you get a situation where somebody gets killed. But I want to think about all the cases where nobody gets killed. Those cases, they were my bread and butter. That's what I did. I did some larger cases, but for the most part, I did not do large cases. I did medium-sized to small cases. Now, the really small cases, and here I'm talking about civil law, right, not criminal law, because there's only one place where criminal law figured and it wasn't good, and I'll get to it in a minute. But the really small cases in a civil case, you couldn't afford to bring. I mean, the case where somebody got stopped for no reason and harassed on the street and maybe, thrown up against the wall, but didn't suffer any real damages. Maybe they were bruised. They were definitely, their rights were violated. You could have no doubt about that. But, what's the case going to be worth to a jury? That's what you have to think about ultimately. Maybe it's like a $5,000 case, a $10,000 case. Is it worth litigating an iffy case? Because it's going to be iffy because you're going to have a swearing contest for $10,000. It's probably not. So you're probably not going to bring that case. So there's like a host of those cases that I think you don't even think about bringing much. And that is true, even though I typically litigated in federal court under a statute called 1983, which has the beauty of an associated statute, which gets you attorney's fees if you win. Theoretically, the winner is entitled to attorney's fees. The reason I say theoretically is because most cases settle. And so what's going to happen is you're going to take that case, and at some point it's going to settle. And when it settles, it's going to settle for damages plus attorney's fees because the defendant only wants to write one check. And so, you're not going to get your attorney's fees. I had one case in all the years I did where I got, I don't know, maybe $5,000 in damages and $80,000 in fees, which is theoretically possible, but it doesn't happen very often. If you get $5,000 in damages, you get a third of it. And so you get $1,700 in what you get, and you can't bring those cases. So then you look at the middle cases, and there aren't that many of them because they just don't crop up. Where do you get them? You get them because if the police hurt somebody, you could pretty much bet they're going to charge that person with a crime. Now, let's be clear. It's not because that person necessarily committed a crime. It's because if they charge them with a crime, it makes it much harder to bring the civil case. So where I got my cases was from public defenders, because the first encounter my clients had with a lawyer was when they were criminally charged and they had a public defender in front of them. And they'd say to the public defender, "This happened to me." And the public defender would say, "Okay, I'll take care of that later. I'll send you to Shapiro eventually. But right now, we need to deal with the criminal charges." And you need to deal with the criminal charges because if your client, your civil case client, has been convicted of criminal charges, it makes the civil case really hard to win, right? So first things first, deal with the criminal charges. The city was smart. They would offer, and I obviously are dealing with different pieces. Now you've got the prosecutor's office before you had the police, but the prosecutors knew what was going on and they would offer a really good deal. a really, really good deal to get your client to plead guilty to something, because having the client plead guilty to anything was really an impediment to the civil litigation. But let's suppose you got around that. Let's suppose they had a good defense. Let's suppose you counsel them to take the chance and the judge says the word's not guilty, whatever it is, right? And then you get to bring the civil case. In those cases, they bear a remarkable resemblance to torts in a lot of ways, to just assault or false imprisonment or whatever it is, right? That's what they look like. And they're swearing match cases. It's word against word, right? Police says he hit me first. Client says I wasn't doing anything. He hit me first. And so you don't actually see, in a minute, Leonard's going to be talking about qualified immunity. Qualified immunity wasn't at stake in these cases, because if my client's version of events was true, then what the officer did was indefensible. The problem is persuading a jury your client's version of events is true, right? And again, that goes back to, you have to pick your cases. You have to pick clients who are going to be believable for whatever reason. So that all, I mean, I can talk more about that and flesh it out, but I want to talk about one other thing. I mean, that makes it sound like this is kind of hopeless, and what would be the point of taking a whole string of these medium-sized cases? What are you doing that for? And so I do want to talk about what our larger picture. I was not alone in Philadelphia bringing these cases, and we actually worked not together as a firm, but together as a kind of a force for change, I'll say. How did we think that was going to happen? You can sue the city in these cases, right? The law permits you to sue the city if you can allege that there's a pattern or practice that makes this officer act the way he did. And in general, I think there is. I truly believe that what's really going on here is that the cities in general, in Philadelphia then, they didn't supervise officers. They basically didn't care if officers did this. And if you could show that they didn't care, they didn't supervise, they didn't train, they didn't discipline, anything along those lines. And if you could show that because of that, the officer knew they were free to do what they did and did what they did, then you could maybe get the city. And it takes a long time. You don't get that result in any one case. You bring a dozen cases or 24 cases where you're working on the same theory, and each time you get a little bit of discovery about how the city works. Each time you get a little bit of insight. We learned, for example, this was a big moment. Somehow in one case, by mistake, I think, some city lawyer gave us this piece of information, which is that the city kept records about police complaint in alphabetical order by name of the person who complained. These were still paper files, right? This is pre-computer. What that meant is they had no way of tracking officers. They had no idea if there was an officer who's named 50 times in those files, because it was kept by the name of the person who complained. And so suddenly we had a new theory of liability, right? Failure to supervise because you're not even keeping track. And that's what we did, right? With an eye towards, over years, driving up the cost of what the city was doing so they would stop doing it. Because, it all comes down to money. And I think it costs a lot of money to change the culture in a police department. And it wasn't worth it to the city to do. And I think we had some small successes. I think we changed how the city of Philadelphia handled police dogs, because we spent a couple of years litigating police dog cases. And it became too expensive to use the police dogs the way they were using. And the one thing I'll say, and then I'll stop, is that we also worked really closely with reporters, because it really helps to get press. And if you can move beyond the one case and show a bigger picture, show something that the city is or is not doing, then you can get the press interested in what you're doing. And if you can get publicity, then you can get more people involved, right? So there is a way to, I think, work the medium, small cases and make something bigger out of it. But it's no quick fix, and it's nothing certain. And there is a lot more complexity that we can talk about when we get to questions. But I think I will stop there. And I will turn it over to Leonard, who's going to talk about qualified immunity and also pre-seizure conduct. So have at.
Okay, well, thank you. So let me start by saying something that honestly I've wanted to say since 2015. And I wanted to say it to Justice Alito, but he's not here, so I'm going to say it to all of you. And this is what I'm going to say. I told them so. I told them so. What do I mean by that? I was in the US Supreme Court in March of 2015 arguing Sheehan. And Sheehan was a case where police barged into the room of a schizophrenic woman who wanted to be left alone. She had told them that she didn't want to see anybody. She told them to stay out. She told them that she had a knife. They barge into her room, and lo and behold, sure enough, she has a knife. So they shoot her. It was a sad case, and it raises a lot of the issues, including the qualified immunity issue that I'm going to talk about today. But here's how I concluded my argument. This is in 2015. I said, I think the court knows that this is a case with enormous policy implications. And we see this in the news day after day, week after week, where the police arrive to help somebody and they wind up hurting them. And I said, Your Honors, it's only when police officers and public entities are held accountable for actions like those that occurred here that we can expect to see a change in that pattern. That's what I told the Supreme Court in 2015, that unless until that court in particular starts finding liability in excessive force cases involving police officers, we're not going to see a change in that behavior. And so here we are 5 years later. The court obviously didn't take me up on that invitation. They found qualified immunity in Sheehan. And now the latest statistics that I read is that 1,000 people each year, 1,000 people each year are being killed by police. Some, of course, in some very high profile cases. And we hear a lot about, most cops are good, very few of them are bad. And, honestly, I suspect that's true. But the problem is that the bad ones have guns. And so this is the situation that we're in. So what is qualified immunity? When a state official violates an individual's constitutional rights, the individual is able to bring a civil action under 42 USC section 1983, which is the statute that provides a remedy for people who are deprived of their constitutional rights by state officials. It has a pretty inconsistent history. There were probably a century or so when it really wasn't all that effective. But most scholars would say that the Supreme Court breathed life into the statute in 1961 when it decided Monroe versus Pape. But unfortunately, what the court gave it then took away. In a 1967 decision, the court introduced qualified immunity. And it introduced it as a doctrine to limit Section 1983 cases. And it explained that state officials shouldn't face liability for enforcing the law in good faith. So that was the standard, in good faith. Now, Section 1983 says nothing about defenses or immunities, but the court has explained that certain immunities were so well established in 1871, which is when the statute was enacted, that we're going to presume that Congress would have specifically so provided had it wished to abolish those defenses and immunities. So the court then refines this good faith standard in 1982, which is when we first see the clearly established test. And that's the problem today. So currently, the qualified immunity doctrine has two parts. The first part is a court has to decide whether the facts that a plaintiff has alleged or shown make out a violation of a constitutional right. So part one, is there a violation of a constitutional right? Second, the court has to decide whether that right was clearly established at the time of the defendant's misconduct. So over the years, the Supreme Court has ratcheted up this test so that today, I think it's fair to say that it cannot be satisfied except possibly in the most egregious cases. So the Supreme Court, by my count, has done that in 7 ways. So first, the court has held that qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. So that's the standard that you have to prove as a plaintiff who's been shot or injured by police. Second, the court has held that for the law to be clearly established, it has to have been beyond debate that the officer broke the law. So circuit splits become relevant, differences among cases become relevant, all of which undermine the application of qualified immunity. Third, and this is probably the most important, the court has rejected attempts by plaintiffs to cite cases that supposedly define the law at a high level of generality. So in other words, a plaintiff has to find a case that is either identical or almost identical to the case at bar, and we'll talk about what that means. Fifth, the court has held that lower courts can address the second prong of the test, the clearly established prong, before the first prong. And if the courts find that the law is not clearly established, it doesn't have to reach the first prong. So what does that mean? It means that the case law gets frozen because the courts aren't addressing whether there's a constitutional violation. And without addressing whether there's a constitutional violation, you have no ability to argue that the law is clearly established. So the test now avoids the possibility that the law does eventually become clearly established. Sixth, when appellate courts find that qualified immunity doesn't apply, the Supreme Court will often accept cert. And in some of those cases, it'll summarily reverse without merits briefing or argument. And in fact, if it finds that the police were entitled to qualified immunity, it usually uses that to clear its docket. So it grants, vacates, and remands the other cases that are have cert petitions pending for reconsideration in the light of the case that it just decided. And oftentimes the lower courts change their mind. And seventh, it uses these cases, as I mentioned, to decide not just the cases that are before the court, but the cases that are pending. So here's a sample of some of the cases where the courts have found that qualified immunity applies. There's a case where a police officer fired 17 shots at a cyclist who was 100 yards away, killing him in a case of mistaken identity. There's a case where a police officer shot a 14-year-old boy in the shoulder after the boy dropped a BB gun and raised his hands. There's a case where a deputy body slammed a woman after she ignored the deputy's command and walked away. One where an officer burned a woman by detonating a flashbang device in her bedroom where she was sleeping. One where an officer deployed a dog against a suspect who claimed that he had surrendered by raising his hands. And another where an officer shot an unarmed woman 8 times after she threw a knife and a glass at a police dog that was attacking her brother. So as I mentioned, the court has held that in order to prevail in those sorts of cases, the plaintiff has to show a case that is substantially similar. So here's some examples of differences that the courts have found to be significant in denying qualified immunity. Differences between the distance between the suspect and the officers and what the suspect was yelling at the officers. There's a difference in a case between subduing a woman who was walking away from an officer as compared to subduing a woman for refusing to end a phone call. Another is the difference between shooting at a dog and instead hitting a child on the one hand and shooting at a truck and hitting a passenger on the other. And then there's the difference between unleashing a police dog to bite a motionless suspect in a ravine on the one hand and unleashing a police dog to bite a compliant suspect in a canal in the woods on the other. And although it's not a police case, there's one of the most sad cases involving the treatment of inmates that involves these same issues. An inmate was placed in a cell that was literally covered, the floor, the walls, the ceilings, covered with human waste. The inmate was left in that cell for 6 days. The inmate sued. The inmate lost that case on qualified immunity grounds. There was a case that said that filthy conditions is a violation of the 8th Amendment, but that was defined at too high a level of generality. There was a case that involved exactly the same circumstances, but the inmate was left in the cell for 30 days, and the court decided that the difference between 30 days and 6 days was significant, so the law wasn't clearly established. So what does that tell you as a police officer? It tells you that as long as you don't do exactly what some other police officer has done in a case where the court found a violation, you're entitled to qualified immunity. Sheehan sadly was an example of that. We had a case, it was the Alexander case that we relied on in our briefing. The plaintiff in Alexander was a mentally ill man. The officers had arrived at his house to execute an administrative warrant. Rather than allow them to do so, the plaintiff had threatened to shoot anyone who entered his house. So that's exactly the same as Sheehan. And although the situation was fully contained, the officers immediately stormed into the plaintiff's house and shot him. Again, exactly the same as Sheehan. The Ninth Circuit described that as a classic Fourth Amendment violation under the Supreme Court's decision in Graham. And yet in the Sheehan case, this US Supreme Court found qualified immunity without any meaningful distinction of Alexander, and warned the Ninth Circuit in the future not to read its own precedent too broadly. So as far as I can tell, the Supreme Court has only rejected a qualified immunity case recently in one case, and that was Hope versus Peltzer. It's a 2002 case where prison officials handcuffed an inmate to a hitching post for 7 hours in the full heat of the sun, with 1 or 2 water breaks, no bathroom breaks, while the prison guard taunted him about his thirst. And even then, 3 of the justices dissented. So obviously there is something seriously wrong with this doctrine. The other issue that I mentioned is the relevance of pre-shooting conduct. So here's what I mean by this. This is the Mendez case. Angel Mendez, like all homeowners, had a Second Amendment right to protect himself with a gun in his own home. But the police officers entered his home without warning, without announcing that they were entering, and without identifying themselves as police. Sounds very familiar, I'm sure. Angel Mendez was asleep on a futon with his girlfriend, and he thought that someone else was at the door, so he got up to go to the door to see who was there. And when he did that, he had a BB gun on his lap. He lifted up the BB gun to put it aside. At that moment, the police officers, in violation of the Fourth Amendment, entered his house. They saw the gun. They thought that they were being attacked, and so they shot Angel Mendez 15 times. They shot his girlfriend twice. The thing that you hear quite often about these cases is that it's difficult to be a police officer, and police are called upon to make very difficult decisions in split seconds. And there's obviously some truth to that, but the reality is that the circumstances in which split-second decision-making is necessary are often of the police officer's own doing. So in Sheehan, for example, it may have been a split-second decision once they opened the door and they saw Teresa Sheehan with a knife, but they had all the time in the world to wait outside the door and de-escalate. In Mendez, it may have been a split-second decision once they entered his house and saw his BB gun, but again, they had all the time in the world to stay outside of his door and make sure that they entered after not only knocking and announcing, but hearing that Angel Mendez understood that they were there and that they were police officers. Again, that might sound very familiar to everybody. So some circuits have rejected this view that you ought to consider pre-seizure conduct. They adopt what's called a segmenting approach. So in the Mendez case, the conduct that led up to the moment where the police officers had opened the door would be in one segment. The court would determine whether there was a violation of the law in that segment, and then they would turn the page and move to a different and new segment. And that new segment begins with Angel Mendez pointing a BB gun at the police officers, and it's decided without any consideration of the previous segments. And so in a segmenting approach, there's no question that what the police officers did was reasonable because they were being threatened with a gun. In Mendez, what the Supreme Court did was it abrogated the provocation doctrine in the Ninth Circuit, which is one way of looking at pre-seizure conduct. And we had asked the court, upon abrogating the provocation doctrine, to adopt what's called a totality of the circumstances test that would consider, just as the name implies, the totality of the circumstances, including the circumstances that precede the use of force. The Supreme Court punted. It abrogated the provocation doctrine, and then it refused to instruct lower courts on what to do with pre-seizure conduct. So what's the remedy? So the remedy is, first and foremost, I believe that qualified immunity should be abrogated. One purpose of qualified immunity, obviously, is so that police officers don't feel like they have a choice between their pocketbook on the one hand and their safety on the other. But there was a study that was done recently where indemnification of police officers is now a universal practice. So this is an issue where cities and states can obtain insurance, and they do, and they can pay out the tort judgments without regard to qualified immunity. And over time, the police will adjust their conduct accordingly. And that's really the second issue, which is the relevance of pre-seizure conduct. Again, we hear that hesitation can be deadly, and we hear that all the time from police. But the time to hesitate is not after being threatened by a suspect. The time to hesitate is before putting yourself in a position where you can be threatened by a suspect. And I believe that if the court were to rule that totality means totality, the result would be safer, not just for the suspects like Breonna Taylor, for example, but also for the police, because it would put them in a position to think carefully about situations where they're putting themselves in danger. So that's all I have to say. Mike Russo is our next speaker, and he's going to address institutional resistance that one faces in trying to defend people that are criminally charged after being subjected to police use of force.
Okay, thank you. I'm going to try to go quickly here because I want to save plenty of time for questions. The thing I want to address here, at least to a certain extent, is what would have happened to George Floyd or Michael Brown if they had survived their encounters with the police. What would have happened next? Or what would have happened to Rodney King? Going all those years back in Los Angeles, this is where I spent my career. What would have happened to Rodney King if the video of the brutal beating he survived as a result of the police hadn't been, as a result of what the police did, hadn't been released 2 days after the beating happened? Because nothing has changed since then, and in many ways it's gotten worse. And I think there's something we need to recognize, going all the way back to that Rodney King case, that for everyone to see 13 police officers were out there while he was being beaten by about 4 or 5 of them. Officers from 2 different stations in the LAPD, officers from 2 different law enforcement agencies, both LAPD and the California Highway Patrol. There were 2 sergeants out there, supervisors. And one couldn't come away from seeing that horrible video without saying, this is institutionalized. They don't think anything is going to happen to them as a result of this because they've gotten away with it time after time. So when I would meet clients who suffered those kinds of beatings, despite the fact that they looked for all the world like victims, they were the defendants in the case. And they were charged with things like battery on a police officer or felony resisting arrest or evading arrest. And maybe in the case of Rodney King, had that video not come out, he'd been charged with the DUI. Maybe if George Floyd had survived, he'd been charged with passing a $20 bill that was counterfeit. And maybe Michael Brown, if he had survived, had been charged with petty theft. But once they come into the system, the criminal justice system and the police department would then have pursued the typical course of action that I always saw in these cases. The goals are, number 1, to protect the police officers involved. Number 2, to justify the use of force. Number 3, to obstruct and resist the discovery by the defense and the investigation we wanted to do into the background of the officers involved. 4th, to create as many hurdles as possible for the defense to lengthen the time necessary to fully investigate the case. Fifth, to get a conviction by any means, by either a plea or taking the case to trial, so that, and especially a conviction for battery on a police officer or resisting, which is going to demolish the possibility of a civil suit later. And why? It's to disable that civil suit. It is the protection of both the city and the police officers involved. So how are those goals accomplished? This is what I saw time and again in a quarter of a century that I was a trial lawyer down there. Bearing in mind that the defendant will likely be in custody, awaiting trial while all of this is happening. Okay. First, there would be a slow and very selective release of information by the police department and discovery. It would just dribble out rather than come out all at once. There'd be a drawn out internal affairs investigation or an officer involved shooting investigation by an internal LAPD or Los Angeles Sheriff's Department team, and I'm sure this is true elsewhere. And that would be confidential. And the idea here would, the stated reason for that investigation is to establish whether or not the use of force was justified and, quote, in policy. And despite the fact that there might not be much complexity to it, it would take months and it'd be confidential and we would get absolutely nothing. And they would try to keep those things confidential. So even when the case was closed and the finding was that the use of force was in policy, our requests for discovery were generally denied. So all of it's confidential. And after all, the officers who are involved in these cases are being investigated by their fellow officers who have a vested interest in seeing to it that their use of force is justified and that it was in policy. So next, there would be a motion by the defense in every one of these cases for discovery of past acts of the officers, in which they might have lied in police reports and been caught, in which they may have perjured themselves on a stand and gotten caught, in which they had used excessive force and gotten caught, or at least there were complaints against them made for those sorts of things. What I had to do in those days, and it is still the truth now, although they shortened the time just by a little bit, I'd have to give notice to the court in a motion, the LAPD or the Sheriff's Department, the prosecutor, the county prosecutor, and the city attorney of a motion to try to discover the personnel records of the officers involved. I'd have to file an affidavit stating what the facts of the case are and why I thought any instances of misconduct would be relevant to defense in the case, usually tied, for those of you who took evidence, to Rule 404B, basically prior bad acts by the officers or pertinent traits of the officers. That service had to happen 10 court days, a minimum of 10 court days before any order would go out for the police to show up. So you're building in 2 weeks. Again, the person you're defending is in custody. The police department would have to respond to court with a city attorney. And when they came to court, they'd come in with the officer's confidential file. This is all assuming the judge found on my moving papers that I had established a sufficient case to even have this happen. But assuming I had, and I better, that's on me, right? The police department representatives and the city attorney would go into chambers with the judge in an in-camera hearing. In other words, no one was there but the judge, police department, and the city attorney and a court reporter. The judge would review whatever files the police department brought in response to my motion, which detailed the misconduct by the officers involved. And the judge, in the sole discretion of the judge, would decide whether I would be entitled to find out anything about that past misconduct. And if the judge decided in their sole discretion, under the abuse of discretion standard, that I wasn't entitled to anything, I didn't get anything. But if I did get something, all I would get after that hearing was the name and address of someone who had made a complaint at some point in time against the officer or officers involved. I wouldn't get any reports. I wouldn't get any interview summaries. I wouldn't get any dates. I wouldn't get anything other than the bare list of names and addresses. And then it was on me, by the rules that were established there that are still in place, to go out, myself and my investigator, and try to find all these people and interview them to see what it is they had complained about, because we weren't even told that, whether it was a perjury complaint or a false report complaint or an excessive force complaint. And many times these addresses and names were from things that had happened years before, so we couldn't find the people. We wouldn't get anything else than those names and addresses unless we could establish that we had exhausted every ability we had to find and interview these people. We had to then make another showing that we had engaged in due diligence to find them and to find out this information. And then maybe the court would release just a little bit more interview summaries with the police to us. And maybe they'd give us more information in those interview summaries that would allow us to try to find the people. And that meant another round of looking for them and trying to get them into court, because that's what we were trying to do. And even if I pulled all of that off, meanwhile, while my client's sitting in custody, usually facing these charges, successive offers are being made by the prosecutor. Sweeter and sweeter deals for just plead to resisting arrest. We'll reduce it to a misdemeanor. Just plead to battery on a police officer. We'll reduce it to misdemeanor. We'll give you time served. That's exactly the kind of thing that would go on and on. And the judge would be pushing us to settle the case, the prosecutor to move it along. That's what you face time and time and time again. And if you got all that done and you lined up witnesses to come into court to testify against the officer, then the prosecutor would make a motion, of course, to exclude that testimony under the state equivalent of 403 by saying that the probative value of that testimony was substantially outweighed by the danger of prejudice to the officer, unfair prejudice or wasting of time or whatever it was the judge wanted to say. So I'm going to stop there and just say that in the end, reform, you want to reform the system, reform all of that. None of it makes any sense. And it made it almost impossible to defend people. And yet we did it time and time again. And if we could win their case, if they hung on, if they let us go to trial and we won their case, then we go to lawyers like Julie with all the information that we had and say, here's your lawsuit. We finally did it. But even if we won, do you think anything ever happened to any of those police officers? Even when we caught them in a lie on the stand, you think the prosecutors would do anything about it? In my experience, no. So that's all I'm going to say for now. I'm sure you have lots of questions, so I'm going to turn it back to Professor Gardner.
Great. Well, thank you all. That is a lot to chew on. And like you said, I'm sure people have questions. So let me just open up the floor right now.
Actually, can I just respond to Mike's? Right. So we lived for PDs like you because that's what we needed, right? We needed more than the information you could give us is we needed the client to escape the criminal system. And sometimes that happened, I think, almost by mistake. We would really try to conceal the fact that there was a civil case in the offing. And this is kind of a pathetic commentary on Philadelphia, but there were so many cases of police abuse that it was hard for the police to know sometimes which ones were going to result in civil litigation. And while they would have loved to convict everybody, they didn't know kind of who to go to the mat with. And so sometimes the PD, the public defender, would just sort of take a really low profile. And I think kind of by mistake, clients would kind of slide through and prosecutions wouldn't happen. And then we would seek exactly the information you described. But in the civil case, it's a different dynamic because if the city can't produce it, the key is you have to allege that the city isn't paying attention to what officers are doing. And you have to make that allegation in a way that sticks. And there are pleading standards that makes that hard. But if you could do it, then the city can't say it's hard for us to find or it's difficult, right? Because if it's hard for the city to find, then they're essentially agreeing that they don't have the information at hand and it manifests their failure to supervise. Having said all that, they always indemnify, right? I mean, what Leonard said is true. They always indemnify. You never get the individual officer. I think that that's true too. But I think in a way, the game is really about getting the city, because if you could make the city want to change the culture, then I think the culture would change. And I think that's a more likely way to make the culture change than by going after individual officers. So you need the individual officers to go after the city. But I think it's wrong to not see this as a systemic problem. It is, and I think we all agree on that. It is a systemic problem, and so you need to go after the system. And there are ways you can do that fairly directly if you have the right vehicle. And that's where the criminal prosecution's a killer.
Alex, go ahead.
Hi there. I just wanted to thank everyone for giving us that information. It was a super interesting set of information to absorb. I was wondering, in your experience, how much people know of their rights when they complain about or when they tell you about police interacting with them. Are they aware usually that something has been done wrong to them, or is that something that kind of comes out when you're getting the facts of what happened to them?
I think
Yes.
people have had a pretty strong sense of when they've been mistreated. I mean, they might know it was a violation of rights, but they had a sense of a bad thing happened to me, and it was, they shouldn't be allowed to treat me like this. And then you had to sort of translate that into whether or not they had a right.
Yeah, the cases that I have in mind, it was absolutely clear. In other words, I was called to appear in an arraignment for someone, and I would come downstairs to the lockup, and the person had looked like they had been hit by a train. They were in bad shape. They were all cut up. Maybe their face was all scabs because they'd been ground in the ground. Or I was called to go to the jail ward at the hospital, and someone had been shot. So those are the cases I have in my mind. It was obvious. Our first job was to document what they looked like and what had happened to them. And of course, then you're thinking, this is the defendant, because they look like the victim, as I said.
Megan, go ahead.
Yeah, so this question is for Professor Feldman. You spoke about this segmented approach where the court would look at one piece of the event and maybe not look at the pre-seizure conduct. Could you maybe talk a little bit about why this is even a thing? Because to me, or why that's how the court can find that to be reasonable. Because in any case, I think if you looked at 1 minute of it, it changes the whole case. And so it doesn't make sense in this sort of kind of high profile and really important sort of work that the court just kind of arbitrarily decides, oh, we're starting at minute 4. Minute 1 through 4 doesn't matter.
Yeah, so that's a really great question, and it highlights the importance of little tiny phrasings in Supreme Court decisions. So there's a decision called Graham, and Graham talks about the avoiding having courts second guess the actions of officers. So, it's the hindsight bias. So Graham's a decision about the hindsight bias, and it uses this language about assessing the reasonableness of an officer's actions, quote, at the moment, end quote. So that's the phrase, 3 words, at the moment. So that's what Graham said. And like I said a moment ago, the reason Graham said that was because it wants the courts to put themselves in the shoes of the police officers and not second guess them based on hindsight. So I've taken the position, and many courts have as well, that the language at the moment is really about this second guessing issue. But a number of courts have said, no, at the moment means at the moment. And so because of that, we have to adopt this segmenting approach. So we get rid of everything that's not at the moment. That's the legal reasoning, but I think we all know that something else is going on here. There are, in my humble view, judges on our courts that do not believe a police officer can do wrong. And so when the police officers come before them, it doesn't really matter so much what the facts are, what the law is. It's the question of getting to what the court believes to be the right result. I think that's true, for example, of Justice Alito, a very staunch believer that police can do no harm. And so when you look at a case like Graham, you can always find some language that is amenable to one view or the other. And then it just becomes a question of how you interpret it. And I think that language, quote, at the moment, end quote, has been seriously misunderstood. And one way to look at it is you can just imagine like the most absurd situations. And these are, things that are happening today. Police jump out of a car. It's an unmarked car. They're wearing plain clothes. They accost a suspect. The suspect immediately feels like he's being mugged. So he fights back. And if you stop and you look at that moment, then the suspect has threatened the police officer and the police officer is justified in using force. Big problems, as we all know, with these no-knock warrants. No-knock warrants, I think, are a remnant from the war on drugs. They're designed to make sure that people don't flush the drugs down the toilet. There's no reason today why we can't let suspects, if they're going to flush their drugs, let them flush their drugs, but give them warning that police are coming in, because we have a Second Amendment right that some people believe very strongly in to, defend ourselves in our homes. And nobody should be shot by police for defending themselves in their home. And one way to assure that doesn't happen is to look at the moments before the use of force. And so I think that, this argument, it has no basis in the Constitution, it has no basis in case law, and it leads to absurd results. But you asked how it happened, and it happened from 3 tiny words in one decision.
Thank you. Yeah.
Manny, go ahead.
Yes. So I have a question. So maybe if I become a public defender and I am to see a client that obviously will in the future have some civil litigation, how would I encourage the client to keep fighting, even though maybe the DA and everybody else has intimidated him?
Well, that's tough. Look, all I can say is that if you speak to somebody as a defense lawyer who tells you that they're innocent, then number one, take that seriously. You're not in the business to plead innocent clients. Now, they can do whatever they want to do because it's their life, not yours. But what you have to talk to them about is all that means if you plead guilty. And if they are complaining to you about, what you legitimately feel is a terrible excessive use of force against them, and they're legitimately not guilty, you're going to try to say that one of the things that's going to happen if you give up is you're going to give up that lawsuit. But that's kind of secondary to the place at which I was coming into the case, which is you're charged with the crime you didn't commit. And we're not here to have you plead guilty to a crime that you didn't commit. The answer to that is to go to trial. But as I said, that is their decision. And you can't stop them. You can't stand in their way. You can just sort of say, here's how I'm going to try the case. Here's the ways I'm going to try to find to win it. But I don't have any great answer beyond that.
Can I have ask a question, Mike?
Yes.
I assume you have to tell them that if they go to trial, there's a chance they could be found guilty, even though they're in fact innocent.
Of course.
Yes,
And
if I was a client, that would be it for me.
Yeah, I mean, you have to be honest with them. Plus,
Manny's question's really, it's really hard for a client to turn down a really good deal.
Yeah. And plus, they're going to get punished if they go to trial and lose. It's going to be a lot worse in terms of the sentence than what they're offered. And you have to tell them that too. It's very hard to stand there and say, yeah, but you should go to trial and place that all at risk. And then the next question is almost always, well, can you guarantee I'm going to win? And I said, of course not. What do you think happens? It's I think the worst days I ever had, to be honest with you, as a public defender, weren't trying really hard cases. It was standing there next to someone who was pleading a case where I didn't think they did it. Because I'm not in the business to do that. It's horrible. It's a horrible feeling.
By the way, I actually think you could construct this theory of municipal liability based on the filing of criminal charges against people who were injured. It would take a long time and a lot of work to prove up that theory, but it's really clear to me that that is a systematic approach that cities use to protect the police, and the police know it, right? They know they're not going to come to grief.
Yes, just a quick story about that from Mendez. So Angel Mendez got charged with, pulling a deadly weapon on an officer. He had his leg shot off. He was in the hospital. They opened up an investigation into his crime. So it wasn't the police officer shooting his leg off. They opened up an investigation into his use of this BB gun against the police officers. They got a warrant to investigate, so they used that to search his house. They showed up at the hospital where he was lying on a bed with his leg amputated. Those of you in criminal law know that you have to Mirandize somebody who's in a custodial interview. So the police told him that he was free to leave. And he said, well, I'm missing my leg and I can't get off this bed. And they said to him, well, I mean, other than that, you're free to leave. I mean, and Julie's point is a very good one. These are the kinds of things that are happening to not only persuade people to plead guilty when they're innocent, but also give away their civil claims. It's very difficult to do this.
Rev, go ahead with your question.
Hi, thank you, everyone. And my question is for Professor Shapiro. I was wondering exactly what evidence that the city isn't paying attention to the police officers looks like, and how would you procure that kind of information?
So you would ask them about their ability to, you'd ask for the records on this officer. And once we knew how they maintained their record system, we'd ask them, how do you keep track of police complaints of police excessive use of force, right? And if the answer is, well, we have these files and the files are kept by name of complainant, then you need probably an expert to say the obvious, which is if you're keeping the files by who complains, then you're not keeping track of which officers are being complained about. Maybe you couldn't even do it without an expert. So you're looking for, the nice thing about failure to supervise is what you're looking for is what they don't do. And there's rather what they do, right? So it's like, they don't keep track by name of officer. You can ask them questions. One of our favorite lines of attack was, tell us how many officers have been disciplined for excessive force in the last year, right? Because if we can get answers like none, or we have no idea. Actually, we have no idea is even a better answer than none, because we have no idea is you're really not paying attention, right? None is pretty good, but at least then they're paying attention. So you're looking for, you have to think about, and you talk to experts. I mean, there are experts who used to run police departments and don't anymore mostly. And you talk to them about what record keeping would you have if you really wanted to keep track of who was doing what? What would supervision look like? What would disciplinary hearings look like? And then you ask about it in discovery. And usually what you find out is they don't do anything, because that's what's there, right? And so you can live with that, right? You can live with the fact that we can't produce any other records of this person's misconduct. That suddenly becomes a good thing, right? Where it had been a bad thing, it's a bad thing as to the individual officer, it's a good thing as to the city. So you get to sort of do this flip thing. I just, while you've asked your question, and I know we're about to go, I just want to say one thing. If I were doing this work right now, I think I'd drop the 1983 cases and bring torts in Washington state courts. I don't know exactly what the law in torts is around that, but there's no qualified immunity for a tort, I don't believe. You would lose your right to attorney's fees, but I would give that up. And if my court of last destination were the Washington State Supreme Court, as opposed to the United States Supreme Court, I'd feel real sanguine about that. It might be that you'd need to change some law in Washington to make that work, but I'd even feel more sanguine about trying to change law in Washington state than I would about trying to change law federally.
So it's kind of a out of the frying pan into the fire situation. You avoid qualified immunity, obviously, which has become just the death knell of Section 1983 actions. What you run into is the statutes in the Washington pattern instructions on defense of self and use of deadly force. There are other immunities in different states. So
right.
Some states, for example, have discretionary function immunity.
Yeah, no, I was just thinking here, I think I'd rather land myself in a Washington state court, and I'd rather take a shot at the Washington state impediments in the Washington state
well, I think we're going to see how that turns out pretty soon. The Charlene Lyles shooting. So the Charlene Lyles shooting case, another situation where police went supposedly to help somebody who was having difficulties, mental disability issues, and wound up shooting her. That case was brought in state court. It was dismissed by the trial court for lack of evidence on negligence. And it's going to get decided by, I think, Division I of the Court of Appeals. So hopefully we'll get some precedent pretty soon. It may not be good for Charlene in terms of the ruling, but hopefully the law is developed in a way that's helpful.
All right, well, that sounds like another subject for a future panel. All right, well, thank you so much. This was incredibly informative. Megan, I'm so sorry. I hope you'll follow up with whoever your question was for. Thank you all so much. Hope to see you at the next one of these.
Thanks, Charlotte.
Thank you.